go ahead and get started. Again, thank you all for joining this morning for our next installment of the Bench2Market Talk series. My name is Courtney Law, and I'm the Managing Director of Biolocity. And this series is co-sponsored by Biolocity, the Georgia CTSA, and the Pettit Institute for Bioengineering and Biosciences. Today's talk is on contract law and licensing strategies, and it should be a great discussion. Before we get to our speakers today, just a few logistics and things to be aware of for upcoming events. So again, today is our contract law and licensing strategies talk. You can see our full series schedule at biolocity.godtech.edu. So we've got 2 more talks for this school year, but we will restart again in the fall. Our next talk will be held on May 18th, same time, also virtual. It will be on investment and dilution with James Stubbs. James Stubbs he's got over 20 years of commercialization experience and has held senior executive roles at different medical device startups. He teaches medical device design at Georgia Tech. And this will be a great interactive webinar to really review the basics of equity negotiation, fundraising, and dilution. So you can go to our website. So again, biolocity.godtech.edu/bench2market to register for the next talk. Another item I'd love to share with you is around some of our commercialization resources. So currently in partnership with the Emory School of Law and Professor Nicole Morris, we offer legal office hours. We have a range of topics or areas of interest that are available for discussion, as you can see on this list. In order to make an appointment, you'll have to go to our website again and request an appointment, and we can get you connected. Another opportunity I'd like to share is Biolocity is a part of the BARDA Drive Accelerator Network. They are a funding organization that are looking for different areas of interest for either funding or partnership. Typically, their awards are up to $750,000, and listed here are their current open areas of interest. If you're interested in talking more about what these opportunities look like or how to get connected, please contact our team, and we can share more about the application process. And so without further ado, I would like to turn it over to Biolocity's Associate Director, John Nicosia, to open up the panel discussion around contract law and licensing strategies.
Thank you, Courtney. So as Courtney mentioned, I'm the Associate Director of the Biolocity program, and I'm really excited to introduce our panelists today for this licensing talk. I will just kind of go, I guess, counterclockwise from my screen. So why don't we start with Todd Scheer, just to give a quick intro on yourself, a little bit about your background.
Yeah, thanks, John. So Todd Scheer, I'm the Associate Vice President for Research and Executive Director of the Office of Tech Transfer at Emory. I've been at Emory for 19 years, but spent the last 30 years in academic technology transfer at 4 different institutions on the West Coast and now the East Coast. Before that, I got a PhD in toxicology, and I look forward to the conversation.
Fantastic. Thanks so much, Todd. How about you, Mark?
Mark Coburn. I'm Interim Director of Technology Licensing at Georgia Tech. I've been with Georgia Tech about 4 years, but have a career spanning a number of universities: University of Southern California, University of California, Santa Cruz, University of Rochester, Virginia Tech, and now Georgia Tech. So I think I bring to the table a lot of different experiences from public and private universities.
Great. Thanks, Mark. All right. And how about you, Nicole?
Hi, good morning, and welcome to those who are joining us. My name is Nicole Morris, and I'm a professor at the law school here at Emory, and I'm also the director of our technology law program. So we work with innovators, PIs, or researchers at Emory or at Georgia Tech and we help them think about the commercialization strategy and framework for bringing early stage technology to the market. So I have a JD from University of Minnesota. I practiced patent law and patent litigation for about 13 years, in addition to some in-house practice before coming over to Emory. Been at Emory now 7 years.
Great, thank you so much. So to kick us off, maybe we can just start right at the beginning. We're just talking about kind of what are the basics of a license and what is a license to begin with. So maybe, Nicole, I'll ask you to put your law professor hat on and just kind of walk us through the basics of this contract.
Yeah, so, a license is really nothing more than a contract or an agreement between two or more parties. And what's controlling about the agreement and what makes it slightly different, it's an authorization from the licensor or the owner to a licensee to either sell or to use whatever the licensed material or products are. So the document in and of itself controls how that authorization will flow, whether it's an exclusive grant of rights or if it's a non-exclusive grant of rights, if there's some geographic or scope limitations to what's authorized and permitted under the agreement. But it's basically an agreement where the owner of technology, which is probably what's apropos for today, will grant the licensee an authorization to use, or it could be an outright sale of that technology. And the licensee will pay some kind of royalty or lump sum to the licensor for that right.
Great, I think that's a great intro to kind of what a license is. And I'm wondering from our tech transfer context here, what are some of the key terms in a license agreement that are kind of like first negotiated? What are the sort of hot button issues?
I'll just jump in quickly and add that one of the a real differentiator, at least for academic-owned technology, and it isn't that it's not the case in business-to-business contracts, but it's especially important in academic licenses because we are recipients of public funding, is to have due diligence language in a contract to assure that the licensee is performing, and if they're not, to return the rights. So it's not okay, well, it might be okay for business to out-license its technology to another business and let it sit on the shelf at the other company if they decided not to move forward with it. I'm not saying they would do that, but they could do that. It's not okay for university to do that because of the public funding obligations and stewards of public funds. We need to get that technology back. And should we be successful in finding a new licensee, then that is an obligation that we carry with that technology for as long as the intellectual property rights are alive.
Great, thank you for that.
I think in building on what Todd said about diligence, one of the things we require of our licenses is a commercialization plan for the technology. So we like to know that whether it's a startup or a medium-sized company or a large company, that they have a plan for commercializing the technology. It doesn't have to be a full-blown business plan, but just something about the team that's put together, what they think of the market, what do they think are the challenges and opportunities behind the technology, and some financial projections too. Do they really think they can sell this on the market, and what are they going to sell it for? What kind of profit are they going to make? We know it's maybe blue sky projections, but we use that to talk with the startup company about appropriate license fees, for instance, that we're both kind of talking from the same sheet of music.
Yeah, maybe one other thing that comes to mind too, and I'm sure there are others, but is the need to retain the ability to publish and retain the ability, a reserved right or a reserved license for the university and the federal government, if they are a sponsor, to practice and use the technology in further research. So there's always that reservation of rights. Again, that might differentiate somewhat an academic license, academic to company license compared to other types.
Yeah, that's a great point, and I appreciate all this. It strikes me from this conversation that a license is, more than just a simple kind of transactional agreement authorizing someone to use IP rights. that there's also an element of kind of business strategy here, this forecast of how this IP is going to be developed, what's happening. So to that point, who is all involved in these conversations, between the inventor, the tech transfer folks, the licensee, kind of how do these conversations, come together?
Mark, you want to go first?
Sure. Generally, we're talking mostly about startups. We're approached by the faculty or student innovator to initially start the discussion. So often, they're the inventor. We've had a policy in the past of not negotiating directly with our inventors, but often they're right on the cusp of leaving the university, especially if they're a postgraduate or a graduate student. So we've started those negotiations with the inventors while they're employed by Georgia Tech, but then they're leaving, and that's a little bit easier to talk to them about terms. If there's founders involved, then we'll keep them informed of the licensing negotiations at a high level. We generally don't, involve inventors directly in our license negotiations, but they may be valuable assets from the standpoint of coming up with technical milestones that we may not know as much as they do about the technology. So they're helpful in evaluating those milestones that might be put forward by the company.
Yeah, it's interesting because a license negotiation is one of those things where I think the general rule is the smaller the party, the better, for a number of reasons. One is certainly confidentiality. Usually license negotiations are confidential, and so it's to everybody's benefit to keep the crowd as small as possible. But the other thing too is just as you add more heads and certainly more parties to a license negotiation, it becomes more complicated. Even with regards to joint ownership, which happens a lot at universities, and a good example is Emory and Georgia Tech will jointly own technologies pretty frequently. And we appoint one institution to take a lead in the negotiations for exactly that reason, to try to reduce the number of parties that are engaged in a negotiation, which can take time and complicate negotiations. Sometimes contracts or licenses have technology that's jointly owned with 4 or 5 other universities, and trying to get those negotiations done. It's difficult to keep the party small, for example, unless you've granted somebody else the right to negotiate on your behalf. But we at Emory, we do what Mark mentioned too. We actually have an IRS guideline which prohibits us from negotiating directly with our faculty who have a conflict of interest. And we're prohibited from giving a sweetheart deal to a faculty startup, for example. We have an external fair market value that assessment that has to be done to make sure that transaction is done at a fair market value. Otherwise, there could be private inurement types of concerns that the startup and our faculty could face.
Yeah, I'm really glad you brought that up, Todd. And maybe we could dig in a little deeper. So I know this is a common question for academic innovators. Maybe this is kind of their first go about commercializing some of their research, and they've been in some preliminary talks with their tech transfer office. What are some sources of potential conflict of interest, especially at the onset of this process, that innovators should be aware of, and are there steps they can take to try to mitigate some of these issues?
Yeah, well, the first conflict that occurs, that is, if it's a startup, is literally if our faculty members, and they usually are, and we usually want them to be engaged in the startup. So if they're going to hold founder shares in the company and or serve as a representative of the company or on the scientific advisory board, then in a license negotiation, there is obviously a conflict of interest or a conflict of commitment. Should you as a faculty be most loyal to the institution where you're employed, or should you be loyal to the startup company where you are going to be a founder, hold stock, and have fiduciary obligations? And these are actually very serious obligations to take into consideration. And one of the many reasons why we have tech transfer offices to represent the university in these negotiations. Probably the second most common type of conflict of interest occurs when the startup company then sponsors research back at the institution. And our obligation is to make sure that we eliminate bias from the research that we conduct. And so in order to do that, we have to manage that conflict, because we want to be certain that there is as much objectivity as possible in the research that's being done in the lab, and that is not unnecessarily biased or has a perception of bias because the faculty member holds stock in the company and or can potentially benefit through revenue received under the license.
Yeah, that's a great point. I remember somebody phrased it to me as, when you're working in commercialization in academia, there are bound to be some conflicts that come up just because there are conflicting motivations at a university versus a startup company. But that doesn't always necessarily mean that's a bad thing. I think sometimes properly managed conflicts can be a sign of a productive, commercialization ecosystem. But I really appreciate your comments on how to kind of mitigate that. Nicole or Mark, did you have any other sort of perspectives on conflict and from your experience, or how to manage those?
Add, any of the innovators that we've worked with through the technology innovation program at the law school, we've encouraged them to sort of create this startup or third-party corporate organization for the very reasons that Todd mentioned in terms of their conflict with the university as their employer. But also it's designed to be in the benefit of the university and the faculty researchers, that you manage these conflicts smoothly. And I think they're not a hindrance to trying to help get technology commercialized by the university. I mean, the good news is the university and the faculty or university employee, they're both incentivized to make the deal go through. So it's not an adversarial process, but you just have to be mindful of sort of the obligations that are clearly owed just due to the employment situation.
That makes sense.
There's another area, John, that we've had some difficulty in the past with student-faculty relationships, and especially when maybe a group of students is going off and starting up a company based on a technology that the inventor also, or the faculty member is also an inventor, but maybe is not involved in the startup company. And there can be some supervisory relationships with the students that go south because the faculty member doesn't agree with maybe the startup and what they're doing. And so we need to manage those relationships too. And we just assume that everyone, sort of knows what's going on, but often they don't. And the faculty member may not know that the students are off starting up a company.
Yeah, I think it's a great, oh, sorry, go ahead.
Yeah, I was gonna go ahead and finish that. I wanted to come back to the conflict of interest, but I didn't want to interrupt you in the middle of your point.
All I was going to say was that I think this speaks to what will probably be a recurring theme in this conversation, that I think it's best to keep in close contact with your tech transfer office and discuss these issues up front before they could really become a problem.
Yeah, I noticed that there are a few Emory faculty names that I recognize in the participants, and so I wanted to just go a little bit further out on the conflict of interest limb and say not only is there nothing necessarily bad with having a conflict, it's actually mandated. I mean, we are mandated as recipients of public funds through federal agencies to not only manage conflict of interest and make sure it gets disclosed so that it can be properly managed, but we're obligated to do something with the inventions that arise from our federal funding. And it is a well-known fact that about 25% of the time those licenses are going to be with startups. And it is a well-known fact that about 75% of the time in those startups, that's the whole reason for the startup is because the development of the technology is tied to the scientific experts that invented it. And so it's difficult to create a startup without having faculty having interest aligned with the startup as well as the university. So there's nothing bad, there's nothing embarrassing. I say at Emory, there are two conflict of interest offices. One that's responsible for managing the conflict, and the second one, which is my office, which is responsible for helping you as faculty inventors create conflicts so that they can be properly managed and we can move forward and do everything right.
Thanks. Yeah, I love that description. I think that makes a lot of sense. So So I want to return a bit to just some basics of different contracts that innovators might encounter. And it reminds me, when Biolocity is working with some early stage technology teams, a lot of our teams are approaching this kind of milestone during the time that they work with us. And the discussion comes up of, should I approach my tech transfer office for a full license, or can I do something called an exclusive option agreement? So I'm interested to hear from our tech transfer folks. First of all, what is an option agreement, and when might that be an appropriate mechanism, maybe before a full license agreement?
I would say almost all the time. We're moving more towards an option first and then a license second. The option agreement is sort of a standstill agreement for the university not to license to anybody else while the party that you've optioned with figures out whether they really want to take a license. Often with established companies, that is a true evaluation of the technology to see if they can make it work in the marketplace. With a startup, often it's just getting their act together, perhaps getting funding, and the option agreement can substitute for the license to demonstrate to investors that the university is serious about licensing to the startup. Now at Georgia Tech, we generally give that as a free option to the startup. We might ask them to pay for patent costs during the period of the option agreement. But generally at the startup stage, we don't have a lot of patent costs that are ongoing. We've already patented the technology, and maybe there's some prosecution coming up. In any event, that's been a valuable tool for us to sort of give the startup some time to get their act together, basically.
Got it.
Yeah, I
Hey,
think
Mark, what are your typical terms in terms of the how long you'll allow an option agreement to last?
Generally, they seem to be around 6 months, but I think what's also noteworthy is we're already into a negotiation of the license before that 6 months ends. So it really is just a chance for the startup company to start getting their investment in place and getting organized around the company that they will start.
Yeah, I would say for us, if I had to take a stab at the average time for an option agreement, I guess I would answer that as 12 months. I would also qualify that as saying all of our technologies in the life sciences space. We don't have high-tech technology like Mark does, and the development timelines are slower and a lot more capital intensive. Not that Georgia Tech doesn't have life science-based technologies, obviously, or he wouldn't be here on this panel at the moment. But the other thing I would add is that a lot of times those options get extended in startup situations because the startup has challenges reaching its funding milestones and goals, and that can be a common reason that it gets extended in some cases far beyond the 12-month time frame.
Yeah, thanks for that perspective. And sort of along the same line, beyond options and licenses, there are some other forms of contracts that researchers might come across. A couple that popped into my head are like a material transfer agreement or potentially sponsored research. And I know that from my perspective, back when I was a researcher, I used to think of material transfer agreements as some kind of annoying thing that I had to do before I could send materials from one lab to another. But I know now they're obviously quite a bit more important than that. So I'm wondering from each of your perspective, what are some of these other contractual mechanisms like an MTA or sponsored research that can sometimes be part of the licensing process, if that makes sense? How do you recommend that that researchers kind of navigate these other contracts that they might encounter?
I'm going to let Mark and Todd kind of share the university line, but I'll just sort of share from a more neutral perspective. I think the MTA should be thought of as an operational sort of technique and not tied into your license agreement if you can avoid it. And the theory I'm coming from, the strategy position, is you need it to do a proof of concept, like you need it to continue doing work. It's not a function of an authorization right that would be controlling in the license agreement. So to the extent that it fits within a broader agreement structure, it's probably just proof of your credibility and showing that you're serious about evaluating the particular technology at hand, but it should have a limited sort of scope and role in the sort of larger scene with the license agreement. And then the sponsored research is something totally different in my view altogether, because you're talking about funding and requirements to meet, particularly if it's federal funding, to meet much larger obligations. But the MTA in particular, and this is just, me from an agreement perspective, should be thought of as this discrete operational functionality that you need to do within your proof of concept evaluating technology.
Interesting. So Todd, Mark, would you agree with that kind of usually stands alone, or maybe comes before we would start having these licensing conversations?
Well, it's interesting. There's so much to say about MTAs and DOAs. I'm trying to figure out how to summarize my thoughts around it and then comments. But so there are different reasons that we might be licensing rights to materials. And the most common way that we do it is just for the purposes of making them available to a collaborator to do research. By far and away, most of our materials transfer agreements are for exactly that reason, to either bring biological materials in or send them out, and not just biological materials, but usually in our case at Emory, biological materials to enable research. But those agreements are usually handled by the tech transfer office, because they're usually governed by intellectual property language. So who owns the derivatives? Who owns the modified derivatives? That kind of IP language comes into place. Same things with data use agreements. Data is another thing that more often these days gets exchanged, not just for research, but even in licensing considerations. Data use agreements are now bringing us to our knees in the same way that MTAs were 10 to 15 years ago, because everybody wants an agreement in place for data now, and intellectual property rights are a key component of those agreements. So you have to handle those correctly and efficiently just to enable research. Also, you have to handle those correctly, because if you haven't handled those correctly, or thoughtfully, then you may not have intellectual property rights down the road when the invention does get made using the material. Hence the reason to negotiate the intellectual property language in the MTA. When it comes to just flat out licensing technology, the first thing you have to ask yourself is, what are you licensing? Are you licensing patent rights? Are you licensing tangible property rights? Are you licensing copyrights, trademarks, know-how? So we like to try to keep biological materials considerations separate from our license agreements if we can, to Nicole's point. We don't always do that, because sometimes the licensee wants them to be included in the license agreement. And so we do that at various times. But
That's great perspective. Thank you. And so this is reminding me, I think we've covered a lot about what licensing looks like from an academic perspective, kind of coming from the tech transfer world. But I'd love to get your perspective, Nicole. I know you mentioned that you worked in-house for a company for a while, doing some patent IP management there. What does this kind of look like from the outside looking in? Say a company was hoping to license something from a university or even from another company. How does a business development representative or an attorney at a company like that get involved in licensing, kind of the other side of this negotiation?
Yeah, sure. When you think about the sort of B2B world with licensing agreements, they're always structured around a very specific reason to collaborate. So you've got like a joint development agreement where your business unit will say, we need to partner with company X or researcher Y for the following reason. So it's very articulated in terms of, there are very specific reasons why you feel like you need to go outside the company to get some additional knowledge, get some additional help, or just sort of innovate with others to think about your own specific product development. Now, the considerations that you want to have on the front end of that is who owns all the downstream, intellectual property. If there's intellectual property that will result in the collaboration, how are you defining your sort of current background knowledge and background IP going in to that collaborative arrangement? And I would always ask, my innovators and business folks, like, what's your best, most successful outcome from this arrangement? Is it a new product? Is it you all are able to go off into the sunset with this really novel and creative new process or whatever? But what's the best you can hope for? And get that at least understood, so we can kind of work backwards to say, if that does not happen, how do we manage the risks that are associated with doing this deal? I think generally speaking, most of the like B2B arrangements, the technology is not early stage, right? It's already been somewhat proven out. The innovators sort of have a really good sense of what a future outcome might look like. The duration of the arrangement, fairly short, like we're talking like 2-3 years, maybe 4 years. I mean, I think business people kind of have short attention spans to some extent. They don't want anything that lingers for a really long time. And they're very clear on terms, right? We're not going to spend more than X. We're not going to have, more than this many folks involved in the transaction. So that part is very nice. And then, you're trying to manage, what might come in terms of people falling off, milestones not being met, what additional risk factors that you can at least think of ahead of time and put that into the agreement. But there's a distinct difference between dealing with more mature technologies and really collaborating for the benefit of a really successful outcome, hopefully in the downstream effort, versus looking at early stage technology that hasn't been fully de-risked, that has a lot more unknowns in terms of what it can and cannot do, and then trying to bake in, an agreement with, a startup or someone who's really looking at a very young business opportunity and trying to figure out where you see that going in the future.
Yeah, thank you for that perspective. I love that concept of, early stage technologies not being fully de-risked and maybe a little bit more challenging to negotiate in that sense. And I feel like that's kind of the world that we find ourselves in a lot as academic innovators. So to that point, I know, Todd, you mentioned earlier that some 20-25% of licenses from universities go to startups. In all of your experience, are there certain technologies that lend themselves more to a new startup versus a more established company, this kind of closer to a B2B relationship like Nicole's talking about? Or is it kind of case by case, I guess, in terms of what type of entity you'd be licensing to?
Yeah, well, like most things, it seems like there are sometimes more exceptions to the rule than there are those that follow the rule. The theory goes that if a technology is sort of closer and ready to go, and more of a development and less of a research-like project, that it fits better in an established company with existing resources and capital already available, as opposed to something very early stage where it may be very reliant upon the original inventor and the world expert in that particular area of science to continue to flesh it out. But a lot of times, and I'm speaking entirely from the life science perspective here, because Mark might have a different perspective with kind of technologies he sees. A lot of times it just comes down to who's interested in doing it. Despite some common myths, we almost never have two parties bidding for a technology. We usually are fortunate to have one party interested. And so if a faculty member is interested, and in particular, if that faculty member is interested in trying to develop it and do some more applied type research, a lot of times the best way to get that funding is through the establishment of a company. And so a lot of times that will drive startup formation as opposed to trying to wait for an existing company to come in and take a license.
Thanks, that makes sense. And Mark, I'm curious from your experience as well. As we mentioned, Georgia Tech has a pretty broad range of technologies. Emory has a little more of a life sciences focus. Do you see any kind of any divide in terms of the area of technology, in terms of the potential licensees you'd be engaging at Georgia Tech?
I don't think so. I would second what Todd just said. It's really, having interested parties around the technology. I think the one thing I've noticed in Georgia, which I hadn't experienced at other universities I've been at, is the availability of funding like the Biolocity program or the GRA funding that comes from Georgia, the Georgia Research Alliance. It does tend to stimulate startups. And I think a lot of times faculty get that funding and they're really interested in research. It's just another way to get some more research funds for their project, but they have to start thinking about a startup because Biolocity or GRA won't fund you unless you start thinking about a startup, and that kind of pushes them in that direction, and we end up getting more startups as a result.
Yeah, that's a great point. And it also reminds me, you made a comment earlier, Mark, that sometimes or often Georgia Tech will pursue or execute an option as you're kind of on the way to forming a startup. And you mentioned that might have some implications for a new startup that's maybe trying to raise money. So I'd love to dig a little bit deeper into that, because one of the issues that we deal with our Biolocity teams is, we're a source of non-dilutive funding. We try to help shepherd these projects toward a commercialization event, whether that's forming a new company or licensing to an existing one. But what we always say is that we're a bridge, not a peer. So we're always trying to help them get to that next fundraising level. How does licensing and the negotiation of those terms influence fundraising strategy? Is there anything to kind of watch out for in an early stage license that might be, influence a potential, venture capital round or seed investors, anything like that to consider at this stage?
We're told a lot of things by startups that they tell us their investors tell them, you have to have a low royalty or, no upfront payments and things like that. I just take all those things with a grain of salt. I haven't talked to investors myself, and maybe we should, and get some investor perspectives about what should be in license agreements or not. But we try and be responsive to the team that's coming to us and work with them. But it's sort of a vague idea about what investors really want in terms of license terms.
Yeah, I would say there's this vague concept of what a fair market value deal is, and you can use whatever term you want, but that's the term I choose. And I believe that for most technologies, there is actually a range of fair market value. And our goal at Emory is to try to find the upper end of fair market value, not the lower end of fair market. As a private university, we're not looking to offer low-cost licenses. We're looking to offer fairly priced licenses that still allow a startup, if it's a startup, to go out and raise funding. So if we're outside somebody, and everybody's got their own perception of fair market value, which is why I say it really is a vague concept. But if it's outside their definition of fair market value, they're probably not going to fund the company. I've spent a lot of time talking to investors over the years about this. And, we keep databases within our offices. I'm sure Mark does too, of all of the deals we've been done. I can't tell you how many times I've heard investors say, well, no investor would ever fund that. And I'm thinking, well, that's interesting, because it's well within the range of at least 6 other deals we did that got funding. But it doesn't matter, right? If that investor's not going to fund it, then we got to talk about it, because the only good deal is a done deal. In my humble opinion. There might be a couple of rare exceptions to that I've seen over 30 years. The only good deal is a done deal. So you've got to find a way to structure your deal in a way that allows your company to be successful. And I can tell you that many times over the years, and I'm sure Mark can say this too, we've had to renegotiate a deal and decrease the term. Not one time in 30 years have we ever renegotiated a deal to increase the terms, because the investor said, you know what, there's a little more room for that old university. Why don't you give them a little bit more?
Yeah, that's funny. That I cannot see that coming up in licensing discussions. And you hinted at it, Mark. I'd like to dig in a little deeper. When you do have to maybe do this renegotiation or something, does it does it come down to, are there certain areas that are more important for investors? Is royalty rate it? Equity, I know, comes up a lot in early stage startup licenses. To whatever extent you feel comfortable sharing, are there certain areas of a license that seem to present more of a prickly issue with investors?
I think probably just the equity question. If there's equity involved in, say, an upfront fee, and we're taking equity in the company, that's usually around where the discussion is. I don't think discussions have come up too much around royalties, maybe because we're not asking for enough. Generally university royalties are much lower, in my experience, than we find out, in the industry. And we have some recent examples of that that we've looked at. So I would say around equity. And for the renegotiation, it's probably around milestones. We've just not gotten that right in terms of the company's ability to meet those milestones. So I wouldn't say we're happy to renegotiate, but I joke around that I haven't had a license that I haven't had to renegotiate sometime during its life.
That's a good perspective to have. And I'm glad you brought up milestones. I don't know if we've talked too much about this yet. Could you maybe give a little bit of background on, what milestone payments are, how that kind of fits into a license, and how you structure those milestones in a license agreement?
We don't often have a lot of fees associated with milestones. We're more interested in having commercialization milestones in terms of getting a product in a prototype stage or a final product or some type of regulatory approval. We might build in some success fees down the road, again, just to make sure that the company is serious about commercializing, and there might be a success fee associated with a milestone.
Got it. Todd, did you have anything you wanted to add to that?
Yeah. So particularly in therapeutic deals, pharma, biotech-like deals, the milestone payments can be quite large. We also have them in plenty of medical device technologies as well. But they can be really large, like in the tens of millions over the course of clinical development in a therapeutic deal. Even in an academic deal, although it might be more typical for us to have milestones that total the $3 to $10 million range. These days, they are exceeding that. But the general theory is that we've got technologies at an embryonic stage of development. And if we were to calculate a net present value and make the license reflect that value, Mark and I would close up shop and go home. I can think of 3 times over the last 30 years where I had an MBA student, very ambitious, come into the office and say, you guys are going to a lot of trouble to try to figure out how to negotiate all these back-end components on your licensing deal. You can just calculate a net present value. And so I would just let them do it, and they would come back every time with this really pained look on their face. It's like, oh man, this technology is not worth anything if we have to calculate a net present value today, by the time you calculate risk factors into the monetization. So the way we achieve that, because we're not willing to grant our license for $1, is to put off paying us as risk is reduced. Now, sometimes companies come back, and I've had this said to me many times over the years, well, you're penalizing me for success. And I say, no, I'm delaying payments so that you pay more as the risk is reduced. And that's in part what the milestone payments are meant to reflect. And then the royalty payment reflects that as well. And of course, we only get paid a royalty for products on the market.
Right. Thanks. Yeah, that makes sense. And speaking of licensing revenue, I guess, another question that comes up that I think might be a bit opaque until an innovator's kind of been through this process is, how does licensing revenue get handled? And I know this is probably unique to each institution, so I'll maybe go one by one. Are there any kind of details to share, general sort of strategies for how a university manages incoming revenue from one of their licenses? Maybe we'll start with GTRC.
So we have a stated policy in our intellectual property policy for sharing revenues with inventors and the associated department or school. and then the remainder goes to the university/GTRC. That's generally around 33% of the inventors. I think the only rub with startups is that if we take some equity in the company and then liquidate that equity, we don't share that equity distribution with founders that already have equity in the company. So if a faculty founder has equity in the company, they wouldn't share in the equity distribution that comes down the road. But inventors who aren't founders of the company would share in those revenues.
I see. And does that match, or is that similar to how Emory handles this stuff?
Yeah. I mean, the old general rule of thumb was usually a third to the inventors, a third to the department/lab, and a third to the rest of the university. Emory's is kind of that. So our inventors get 100% of the first 25,000 after any patent expenses. They get 33% of everything between 25,000 and 4 million. And then they get, if I recall correctly, 25% of everything above 4 million. The department and lab share in a third, and then the general university and the school share in the other third. So that's the way it works at Emory. And I will add, I mean, what's been interesting over the years is I found faculty to be almost equally motivated by the opportunity to get a portion of revenue into their lab as they are the opportunity to create personal revenue for themselves. So getting that discretionary funding back into the lab can be very meaningful.
That's a great point, yeah. So we're getting a couple of questions in it, and please feel free to send questions in either through the chat or the Q&A function. We've got about 10 minutes left. Before we get to some of these questions, I did have one other point that I wanted to ask Nicole. So as you mentioned that you're the director of this Tiger program, and I'm wondering how often these issues come up with the teams that you work with in this program. Are they at the stage where they're starting to think about these intellectual property licensing discussions, and how do you advise teams that are going through that?
Yeah, so it comes up maybe 25–30% of the time, not as often as you might think, primarily because once we start really looking at the commercialization framework for the technology, there's lots more work that needs to be done. So it's not like the technology is not ready for prime time. So, that assessment in the program is instructive and very helpful to the innovators, so they know this is where I need to be before I really start some serious negotiations. But once they're ready to do that, yeah, a lot of the conflict issues are the first main points of contention in terms of then you need to think about a corporate formation. Are you going to get some others involved in terms of your founding board? Is it just you? Like, who else will be involved in the new company? And getting set up with, maybe some outside counsel representation, of course, at that point, because you're now not completely adverse, but your interests are definitely not aligned 100% with the university. So trying to make sure that you can negotiate a deal that gives you some runway to be successful and thrive as a business. There are some general parameters that we've already discussed in terms of what happens once you start licensing technology out of the university. But I at least try to give the student teams, like, here's all the options. Like, here's what, other universities are looking at. Here are some, potential things to think about in terms of if you want to remain a university employee versus leaving and fully, supporting yourself through the startup or through this new business. So trying to make sure that they have a good sense of what could happen, I think, is the most important thing that we do, but we don't see a lot of it because through the program, through thinking about value proposition and like, are you solving, the right problem, the main pain point? There's some technology pivots, there might be some design changes, and you realize there's still more work to be done before we really start negotiating a licensing deal.
Yeah, that's a great point. And I'd love to dig into that a bit before we turn over to some audience questions. I like the way you describe it as kind of the technology being ready for prime time. What are, I guess, your perspective, and I'd love to hear from Todd and Mark as well. Like, what are some check boxes about like what would signal to you that a technology is ready to start having these licenses discussions, or at least ready to start talking to their tech transfer office about this?
I'll just give a small, quick example. I think one of the main credibility checkpoints for technology is you have a third party who's interested in doing a deal with you. You verified that there's an established, mature business that says, this is exactly what we need. We'd love to partner with you. We want you to collaborate. What can we do to get involved with your work because we think it has promise, right? So that sort of independent verification that you are solving a problem that's a real unmet need in the marketplace, to me is a signal that you might be ready for prime time.
Cool. Todd, does that line up with kind of your understanding? Is there ever a time that's too early to start talking to your office about these discussions?
Yeah. So my advice to my faculty is come see us if you think you have a scientific finding that might have commercial potential. If you can just remember that, we'll help you with the rest. We're not looking for you to negotiate the license agreement on your or our behalf. We'll keep you informed and participate with you all the way. But we want to talk to you early because there are things you can do that bar our ability to get a patent or good intellectual property protection, which is the basis to have something to license. I can't license published information. It's fine. Most of our technology gets transferred through publications and walks out the door in the heads of the students and the faculty and the fellows that we train. But occasionally things that are going to appear in publications or scientific presentations might be a discovery of a new molecule or a discovery of a new monoclonal antibody or the creation of one. And it may have, and you may think it have, or a colleague may tell you that they think it has commercial potential. That's when you should come talk to the tech transfer office, because if we don't do that and take care of those issues, there will be no conversation around licensing later. And then we'll take care of the licensing. But sort of to your question from the tech transfer office perspective, how do we know when something's ready for prime time? Well, that's a really good question because I don't even know what prime time is. If it's a therapeutic, my definition of prime time is something that has got enough data on it to have a good assurance that we've got a lead molecule or good evidence to believe we've got a lead molecule. That would be an example. For things in the medical device arena, it gets a little bit harder to capture. The neat thing about medical device technologies is you don't necessarily have to make them. Sometimes they're simple enough that they can constructively be reduced to practice, which means in your mind, you can imagine how this particular esophageal intubation tube would work, for example, or be built. So in order for it to be ready for prime time, the requirements might be a lot less. It might just be that we have some good drawings around how we think it would need to be created as a device, and those features that make it novel might make it obvious as to why it could be something that would be useful in the marketplace.
Great, thanks for that. Anything you wanted to add to that, Mark?
Yeah, sometimes the timelines are incredible. We had a therapeutic at Virginia Tech that I went back and talked to the inventor when he first came up with the idea. It was 1995. And it wasn't until 2000 that we actually patented the idea. It was a joint invention with Mayo Clinic. Luckily he hadn't published about the potential therapeutic in that time period. And then we went through a series of studies and patenting, and it wasn't until 2007 that we sat down with AstraZeneca and negotiated a license. And I also kept track of how long it took to negotiate that license. And this was, again, a three-way license. It's more complex when you have more parties. It took a total of 63 man hours or person hours to negotiate that license, where Mayo Clinic, us, and AstraZeneca were all on the phone.
Yeah, that's helpful to keep that in mind.
Yeah, I think our record that I could think of for a therapeutic was 22 years from date of disclosure till FDA approval.
Yeah,
that's Obizur, the chronic hemophilia drug that Pete Lawler in pediatrics discovered, but it was 22 years from the date he disclosed it until the date that it got FDA approval.
And that's Obizer is a huge success story. So for all the audience out there, just because something is maybe taking a little while to get started, keep at it. Sometimes victories happen a little later on.
A little later on, yeah.
Great. Well, I'm keeping an eye on the clock. We've got about 4 minutes left, and I see 2 questions so far. The first one from one of our audience members is, do you ever renegotiate to exchange equity for decreasing or even 0% royalty? From the investor perspective, we often view that as aligning the university and the investor interests, and have frequently renegotiated in our investments to do so. So yeah, I guess from either of our tech transfer offices, have you ever done something like this?
I'm not going to touch that one. No, we haven't done that one. We generally look at it as royalties really demonstrate the success of the technology. We're sort of risk averse at the equity stage. We'll take equity in lieu of an upfront fee, really in recognition of trying to help the startup, but we're not really investors. Maybe that'll change over time. And maybe Emory takes a different view, but my view is that if it's going to be successful, we want to share in that success with a modest royalty down the road.
Yeah, I think my answer would be is that we're always open for a conversation. I'm trying to think, there might have been one time where we did that. I've never had an investor come back and want to give me more equity. I've had investors come back and want to decrease the royalty frequently, but I've never had them come back and want to give me more equity. That seems to be the number one thing they're most reluctant to really want to share with us. I do hear all the time, and I understand our interests are aligned if we're an equity holder, but we know we're not going to make out well. We're an equity holder, particularly in these capital intensive life science deals where we get diluted out. We just won't generate much revenue, and we haven't. We've made really big sums of money off of royalties and very, very little over our equity positions. But would I consider it? I would certainly entertain the conversation. My guess is I would be shocked if the investor was willing to give me enough additional equity to make it a fair trade. But if it were, I would certainly take that into consideration.
Great, thanks. Yeah, that aligns with my experience as well, and I think that makes sense. Maybe along a similar line, another question we got was, can you share some perspective on adding a buyout clause when forming a licensing agreement? So maybe first, what would a buyout clause be for those who might not know?
Yeah, well, my definition of a buyout clause would be a clause in the agreement that sort of gives the licensee the right to buy out the downstream monetary conditions or financial economic considerations in the license, and or potentially even transfer ownership of the technology to the licensee. We almost never have buyout clauses in our licenses. Having said that, every single license we have, it's easy enough. There's always the option to have a buyout conversation, because again, it just comes down to sort of what's the price and whether both parties feel comfortable about that. So the problem in agreeing to a buyout clause that means anything to the licensee is they probably want an assurance, at least if they can't get it over the actual value, it would be over the exact formula that would be used to determine what it is. And there are so many unknowns, even when you're doing a monetization at the time, like we did at Emory for the HIV drugs, the $540 million deal. Those are very, very complicated calculations. There was a lot we didn't know even at the time that the product was approved and on the market. So putting a buyout clause or even a formula into a license agreement at the time you negotiate it is just really difficult and meet both parties' expectations.
That's fair. Would you agree with that, Mark?
Yeah, we don't generally do buyout clauses, but we're happy to talk about them during a license negotiation. I think, and we don't use this agreement a lot, but we have an express license for startups that was developed years ago, which no one seems to want to use, but it has a buyout clause in it. And part of the reason we take the approach that, okay, it's express, we don't negotiate it because it's supposed to be express. So if you want to accept those terms, we can use that license because we offer it up. But I can't think of one license I've done in 4 years, and I offer up that license, that express license to use, and I have no takers. Maybe we need to redo the express license, but.
Right. And I think maybe this just speaks to our earlier, point about how we're working with early stage technologies. And to Todd's point, it's just kind of challenging to forecast what the value of that buyout would be. All right, well, we are a minute over, so unfortunately, I think we're going to have to wrap this up. But thank you again to our panelists. I think we may have lost Nicole here, but I just want to again thank Todd, Mark, and Nicole for all their perspective. I think this was a really interesting discussion, and hopefully all of our registrants thought so as well. So thanks again, and we'll see you back here next month for the next Bench2Market talk.